Good afternoon, everyone. My name is Luis, and I'll be your host for today's Caso Discurso. Welcome to the Philippine Association of Law Schools Bar Operations 2023. Good afternoon to all our participants, and to those who are watching us live, welcome to Caso Discurso. Before we start, just a quick rundown of what Caso Discurso is. It is a discussion of the latest cases decided by the Supreme Court, presented to us by, of course, the Philippine Association of Law Schools in partnership with Polytechnic University of the Philippines, College of Law, Association of Law Students of the Philippines National, and of course, our sponsors, Rex Education and Central Books. We are proud to share to you that Caso Discurso is now on its sixth edition. And we are proud to share again that Caso Discurso is now on its sixth edition. And for those who were not able to watch or see the lectures on remedial law, property persons and succession, and criminal law, they are still available on our Facebook page of the Philippine Association of Law Schools. And of course, just to remind you, we will also have future lectures on commercial law that will be on August 4, taxation on August 7, political law on August 9, labor law on August 11, and legal ethics on August 14. So for those who are watching us live, please like and follow our Facebook page to be updated on the dates and speakers for each program. And again, we would like to acknowledge and thank our collaborators who made this event possible: PUP College of Law, ALSP National, and of course, our sponsors for this event. Thank you so much, Rex Education and Central Bookstore. And now, here's a short video prepared by our sponsors. Once again, thank you so much for our sponsors, Rex Education and Central Bookstore. Now, it is my honor to introduce to you our lecturer for today's discurso. He spent his high school and college days in the seminary and graduated magna cum laude. He passed the bar examination way back 2004. He is a former president of the Integrated Bar of the Philippines, Albay chapter, currently the managing partner of Leandro Millano and Partners Law Office. Currently, he is a commissioner of the Commission on Bar and Discipline of the Integrated Bar of the Philippines. Currently, a trustee of the Philippine Association of Law Schools. He is also currently the dean of the University of Santo Tomas-Legazpi College of Law, a professor in land titles and deeds. Please welcome Dean Leandro Millano. Good afternoon, Dean. It's an honor for us to have you here.
Good afternoon. Am I clear now?
Yes, yes,
Okay.
yes, then you're clear.
Thank you very much. May I request that the uh, bar exam syllabus for land titles and needs be flashed in the screen? Ayan. Okay. So before I start, let me first thank the Philippine Association of Law Schools for spearheading this bar lecture series. And I hope we will be of help to the bar examinees for the 2023 bar exams. Okay, and of course, before I forget, let me greet also my wife, Attorney Tin Miliano, and my daughter, Lauren Dominic Miliano. Okay, baka mapagalitan ako pag hindi ko na-greet. Okay, so let us proceed. You can see the syllabus for the subject. Okay, we will skip number 1 because there are no new cases for that topic. We proceed with the second topic, the Regalian Doctrine. Okay, so I'm sure you are familiar already with the Regalian Doctrine, but let us just restate that. Well, under the Regalian Doctrine, as embodied in our Constitution, land that has not been acquired from the government, either by purchase, grant, or any other mode recognized by law, belongs to the state as part of the public domain. Now, we will focus our discussion to the exception to the Regalian Doctrine. Okay, you are all aware of the exception, specifically the native title, which is the title in favor of the ICCs and the IPs, or the indigenous cultural communities and indigenous peoples, over the ancestral land and their ancestral domain. And both the ancestral domain and the ancestral land are outside the scope of the public domain. Okay, so let us see the recent case involving that exception. Okay, we have the case of Republic versus Sadka. Okay, if you want to get the GR number, it's GR number 218640. And the date is November 29, 2021. Okay, so let us see what happened in this case. So, on August 29, 1975, Akai, a member of the Kankanae tribe, was awarded free patent over a parcel of land in Barrio Abatan, Mangkayan, Benguet. And a certificate of title was later issued in his name. Now, on August 26, 2002, the Republic filed a complaint for the cancellation of the free patent, as well as the original certificate of title. And the Republic alleged that the land awarded to Akai was located inside the Mount Data National Park and National Forest. Hence, they are claiming that it was not alienable. Okay, so the lot was inside a national park and national forest. Okay, so the issue in this case is, may members of the national cultural minorities like Akai apply for confirmation of title to their ancestral land situated inside the national park and national forest. Okay, so yun ang naging issue. How did the Supreme Court resolve this one? Well, the Supreme Court gave three reasons why it sided with Akai. First, according to the Supreme Court, under Section 48C of the Public Land Act, that is CA 141, as amended by RA 3872, members of the national cultural minorities may apply for registration whether the land is disposable or not. Okay, it is specifically mentioned in Section 48 that the classification of the land as disposable or not does not matter. So they can apply for registration. But of course, this is limited only for the IPs and the ICCs. Okay. Now, so whether they are disposable or not, so long as the land applied for is suitable for agriculture, national cultural minority, members of the national cultural minorities may apply for registration. So kahit nandoon yun sa loob ng forest land, they can still apply. Okay? There is a second reason why the Supreme Court sided with Akai. According to the Supreme Court, while it is true that the property is inside Mount Data National Park and National Forest, and it is settled that forest land is considered part of the public domain and cannot be the subject of registration under the torrent system. However, a recognized exception to the rule on inalienability of public land is if the forest or mineral land has been statutorily reclassified and considered as ancestral land, openly and continuously occupied by a member of an indigenous cultural community. So, according to the Supreme Court, by way of exception to the Regalian Doctrine, or the rule that all land belong to the state, land possessed by occupants and their predecessors in interest since time immemorial or before Spanish conquest was never part of the public domain. So, basta ancestral land, they are not part of the public domain. Okay? So, Akay can still register. And finally, the third reason cited by the Supreme Court, there was a presidential decree number 410 issued by then President Ferdinand Marcos on March 11, 1974, declaring that ancestral lands occupied and cultivated by ICCs for a period of at least 30 years were classified as alienable and disposable. Okay? So, since there is already a presidential decree reclassifying all ancestral lands that had been in possession by the ICCs for at least 30 years as alienable and disposable, so it means to say that the property occupied by Mr. Akay is already alienable and disposable despite its location inside the public forest. So these are the three reasons cited by the Supreme Court in siding with Akay. So for the second topic, just take note of the exception to the Regalian Doctrine, which is the native title. Again, if it is an ancestral land, it is outside the scope of public domain, and the ICCs and IPs may register the same in their name. Okay, so going to number 3, nationality restriction on land ownership. You are all aware that there is a constitutional ban against ownership of Philippine lands by non-Filipino. Okay? So non-Filipinos cannot acquire or hold title to private land or to land of the public domain. Okay? So kahit private land, kahit land of the public domain, they are covered by the constitutional ban. Except, there is one exception, except only by way of legal succession. Okay? Take note of the exception, except only by way of legal succession. Now, there is one recent case on this matter, and this one was penned by the chair for the 2023 VAR, Justice Hernando. So we have the case of Gao versus Chua. Okay, Gao versus Chua. GR number 206404. Dated February 14, 2022. Okay, this one is interesting. So, in 1969, the Santoses sold 2 registered land and 1 unregistered land in favor of Lupieng, a Filipino. Okay, so binenta. Lupieng rented these lots to the spouses Chua Chin and Cha Chin, who were Chinese nationals. And they have 7 children rather, namely Concepcion, Ben, Kiam, Pino, Lucio, Juanita, and Julita, who are all Chinese citizens. Okay. So in 1976, Lu Pieng sold the three lots to Lucio, who in turn sold them to Juanita. Okay. And in 1998, Juanita donated the unregistered land to Ben, and later on sold the two registered land also to Ben. And Ben was able to transfer the title in his name. And eventually, Chua Chin died in 1986 while Chachi died in 1993. Okay. In 1996, one of the children, Concepcion, filed a complaint for reconveyance and damages against her brother Ben. Si Ben na yung registered owner at the time. And she claimed that their parents had actually purchased the three lots with the understanding that the buyer or transferee, itong si Lupieng, shall only hold the legal and beneficial ownership in trust for the legal heirs of the spouses. So, kiniklaim nila, there was really no sale between the previous owner in favor of Lu Pieng. So si Lu Pieng was, ang sabi nila, he was only a trustee. So they are claiming that there is an implied trust over the lot in favor of the legal heirs of the spouses, Chua Chin and Chan Chi. Okay. So the issue is whether an implied trust was established over the three lots in favor of the legal heirs of the spouses Chua Chin and Chan Chi. According to the Supreme Court, the 1987 Constitution dictates that non-Filipinos cannot acquire or hold title to private lands or to lands of the public domain except only by way of legal succession. That's the general rule and the exception. And the primary purpose of this prohibition is the conservation, of course, of the national patrimony in the hand of the Filipino citizen. Now, according to the Supreme Court, not even an ownership in trust is allowed. Okay? So, hindi pwede yung transfer or rather the ownership in trust. That is still covered by the constitutional ban. Okay? And sabi pa ng Supreme Court, an implied trust is not a mode of legal succession. Okay? And if you will actually enforce the implied trust, it would be against the law and against public policy. So, sabi ng Supreme Court, the implied resulting trust is covered by the constitutional ban against ownership of Philippine lands by a non-Filipino. Okay, also the case of Concepcion was dismissed. Okay, so that's the nationality restriction on land ownership. But take note also, okay, this topic is often asked in the bar. Take note that the constitutional ban does not apply to foreigners if the property was acquired at the time that they were still Filipinos. Okay? So, when you were still a Filipino and you acquired real properties in the Philippines and you eventually became a foreigner, the constitutional ban will not apply to you. So this was the ruling of the Supreme Court in the recent case of Morales versus De Guia. Okay, Morales versus De Guia, GR number 247367, dated December 5, 2022. Now, the issue in that case, I will no longer discuss the facts, the factual circumstance. The issue in that case is whether Abner, as a naturalized American citizen, retained his ownership over the subject property which he acquired while he was still a Filipino. And ang sabi ng sagot ng Supreme Court, Abner's right to the subject property was not lost by reason of his naturalization as a U.S. citizen. Abner was a natural-born Filipino citizen when he acquired the property from its previous owner. As a result, he is deemed to have acquired a vested right over the property. So, the basis is vested right. Okay? So, nung na-acquire niya yung property when he was still a Filipino, he acquired a vested right on it, and his subsequent naturalization as an American citizen will not affect his vested right. Okay? So, pag ganun ang bar question, alam nyo na ang isasagot ninyo. And take note also, okay, in this topic of nationality restriction on land ownership, take note also that former natural-born Filipino citizens who have lost their citizenship may still acquire property in the Philippines. Okay? Ngayon, hindi ka na Filipino, but previously, you were a former natural-born Filipino. Okay? So, ngayon, kahit foreigner ka na, you can still acquire property in the Philippines. Provided, okay? Provided that you acquire the land from a Filipino citizen who has complied with the requirements under the registration of land. Okay? Take note, you should acquire the same from a Filipino citizen who is qualified to apply for registration. Kung wala yung hindi mo yun na-acquire, for example, you are a foreigner but you are a former natural-born Filipino citizen, if you just occupy a parcel of land, you will not, and if you cannot claim, for example, adverse possession that will ripen into ownership over the land. You don't have that privilege, unlike Filipinos. Okay, so take note, it must be acquired from a Filipino citizen who has complied with the requirements under the land registration. And take note, of course, unlike Filipino citizens who are allowed a maximum of 12 hectares, for former natural-born Filipinos, they can only acquire a small area. Okay, if it is for business or commercial purpose, it is limited to mere 5,000 square meters in urban areas and 3 hectares in rural areas. If the purpose is residential, it's only 1,000 square meters in urban areas and 1 hectare in rural areas. So take note of the limitation in the area. Okay, so moving on to the next one, we will discuss number 4 and number 5, okay, pertaining to the original land registration and then the judicial confirmation of imperfect title, because there was a recent amendment by RA 11573, and this amendment took effect on September 1, 2021, and it is covered by the 2023 bar exam. In fact, it was specifically mentioned in the syllabus. Okay, so let's see what were the changes made under RA 11573. So for 4.1, who may apply, the um, change was in the number of years of possession and occupation. Okay. Previously, it should be since June 12, 1945. But now, you only need to possess and occupy the property for at least 20 years. Okay? So 20 years na lang ngayon. The same na din if you will read the amendment, yung section 14 of PD 1529, which is the original registration, and section 48 of CA 141, which is the judicial confirmation of imperfect title, they are almost the same. Okay? Almost the same. And the particular amendment was made on the number of years required to possess and occupy the land. Okay? So, you only need to possess it for 20 years. But of course, the property must be classified as alienable and disposable land of the public domain. Okay? Now, let us just discuss some important rules with respect to this one as to who may apply. The specifically the classification of the land at the time of the application. Okay, so the first rule, just take note, okay, na that as long as the land is classified as alienable and disposable at the time of the application, it is registrable. Okay, so titignan mo lang, at the time the application was filed, was it classified already as alienable and disposable? If it is, it can be registered. Regardless of the date of its classification. Okay? Kahit 1 year pa lang yan ni-reclassify, it's all right. As long as you already occupied and possess the property for 20 years. But the classification need not be for 20 years also. Okay? So kahit kahapon lang yan na reclassify as alienable and disposable and you were already in possession for 20 years, you can apply already today for registration. Okay? That's the first rule. The second rule, if at the time if at the time of the application it is classified as a forest land, for example, it is, as a general rule, it is not registrable. Except only, okay? Except only if it has been previously classified as alienable and disposable at any time from June 11, 1978, which is the effectivity of PD 1529. Kasi once it was already classified as alienable and disposable and the occupant has qualified already for registration, although hindi pa din siya nag-file ng application, he will already acquire a vested right under PD 1529. And that vested right cannot be impaired by the subsequent reclassification of the property as forest land. Okay? So yung pangalawang rule, simple lang din. If it is classified as forest land at the time of the application, as a rule, it is not registrable, except if it has been previously classified, and there was classified as alienable, indisposable, and there was already a vested right. Okay. Now, if you will look at the uh, amendment, okay, introduced by RA 11573, you will notice that the uh, old section 14.2 under the and in PD 1529, which is the confirmation of land acquired through prescription. Now, this provision has been uh, deleted, or it is missing under RA 11573. So wala na silang specific provision on prescription. Okay? And the explanation of the Supreme Court in the case of Republic versus Pasig Rizal Company Incorporated, okay, that case is specifically mentioned in the syllabus. So, ang sabi ng Supreme Court sa case ng Republic versus Pasig Rizal Company Incorporated, this is because of the shortened period of possession of only 20 years under the new Section 14.1, so that the applicant need not wait for 30 years for prescription to set in. So, ang sabi ng Supreme Court, since 20 years lang naman ang required, hindi niya na kailangan yung prescription. Okay? Now, the pronouncement is, of course, it is not wrong. But if, of course, you are a lawyer, or if you want to become a lawyer, you can also make a different interpretation of that provision. Because take note that the prescription is not only 30 years. Okay? Acquisitive prescription is not merely 30 years. There is also acquisitive prescription of 10 years, which we term it as ordinary prescription. Diba? 10 years and we have 30 years. So, yung sa prescription, I think, okay, that this is only my opinion, you can actually apply this one under section 14 number 3. Okay? Kasi under section 14.3, sabi, those who have acquired ownership of land in any other manner provided by law. So prescription is a mode of acquiring ownership, okay, under the civil code. So this might be covered by section 14.3 of PD 1529 as amended. Okay? So yun ang, it can be a good source of bar question, because of course the bar exam will not only test your knowledge of existing law, but of course it will also test how you reason out for a particular set of situation. Okay? So, but of course, kung ayaw nyong, kung gusto nyong pasiguro, okay, you have to go with the pronouncement of the Supreme Court that it was already deleted. The rule on prescription was already deleted. Okay? Okay. Now, in any case, okay, because again, this can be a good question in the bar. If there will be a bar question, okay, or about prescription, okay, if it's specifically about prescription, I want you to take note of the following, okay, because um, this is the this is also part of the ruling of the Supreme Court in the case of Republic versus Pasig Rizal Company Incorporated. Okay? So take note of the following. This is about prescription. Now, for land to be registrable under prescription, it must be classified as alienable and disposable. Okay, that's the first requirement. It must be classified as alienable and disposable. Second, prescription runs only against patrimonial property of the state. That is the patrimonial property mentioned in Article 420 of the Civil Code. Okay, but not against property of public dominion. Okay? Kasi baga, yung the uh, property of the state is classified under the civil code into property of public dominion and patrimonial property. We'll later on discuss a little about that. Okay? So it runs on prescription runs only against patrimonial property of the state. That's the second one. The third one, the period required, okay, for prescription to set in is adverse possession for 10 years if with just title and in good faith, or 30 years if one or both are lacking. Okay, so 10 years or 30 years, and it will be reckoned from the moment the property became patrimonial property of the state. Okay? So yung prescription will have to be counted from the time the property became patrimonial property of the state. Okay? So just a little discussion on just title because marami ang actually nakakalimutan what is just title. When we say just title, there is a transfer through one of the modes of acquiring ownership, except that the title cannot be actually transferred because the seller is not the real owner of the property. Okay? While good faith naman, good faith, well, it consists of reasonable belief that the person from whom you acquired the property is the owner thereof and could transmit his ownership. Okay? Yun naman ang good faith. Okay. Now, number 4, okay. Once acquisitive prescription is completed, okay, the subsequent reclassification of the property from patrimonial to another classification, for example, into forest land or property of public dominion, again, will not impair the vested right of the owner to apply for registration. Okay, no impairment of vested right. Now, let's just uh, review the classification of lands, because lands are classified under, the first one is under CA 141 and the Constitution. If we still recall, under CA 141 and the Constitution, there is a primary classification of land of the public domain. You have the alienable and disposable land of the public domain. Second, forest or timberland. third, the mineral land, and lastly, national parks. Now, the secondary classification, yung first na primary classification, yung alienable and disposable land of the public domain, they are further classified into agricultural, second, residential, commercial, industrial, or for similar productive purposes. Third, educational, charitable, or for similar purposes. And lastly, reservations for town sites and for public and quasi-public purposes. Okay? So yun ang classification under the Constitution and CA 141. The second classification is under the Civil Code, which I already mentioned a while ago. The property of the state is either a property of public dominion. So these are the ones intended for public use and the one intended for public service or the development of the national wealth. Okay? Yun yung property of public dominion. All the other property are patrimonial property of the state. Okay? Now, the question is there a need, okay, for an express or formal declaration from the government that a particular property of public dominion is no longer needed for public use, public service, or the development of the national wealth before it may be classified as patrimonial property? Okay? So, to be considered as patrimonial property, kailangan ba ng express or formal declaration from the government? This question was answered by the Supreme Court in the Republic versus Pasig Rizal Company Incorporated case. Okay? Take note, it's a recent case and it was specifically mentioned in the syllabus. So, the answer is it depends. Okay. Why it depends? It depends on the classification of patrimonial property. Okay? Meron pa palang classification ang patrimonial property. The Supreme Court made a subclassification of patrimonial property in that case of Republic versus Pasig Rizal. Ang sabi ng Supreme Court, there are two kinds of patrimonial property. One is the patrimonial property by nature. Okay? Patrimonial property by nature. These are properties that are patrimonial property by nature are those which are not property of public dominion or not imbued with public purpose based on the state's current or intended use, and thus classified as patrimonial property pursuant to Article 421 of the Civil Code. In other words, it has no prior state use. Okay? Since wala siyang prior state use, so by nature, these are considered as patrimonial property. The other one is the converted patrimonial property. Those which previously assumed the nature of property of public dominion by virtue of the state's use, but which are no longer being used or intended for said purpose, and subsequently classified as patrimonial property pursuant to Article 422 of the Civil Code. Okay. Ito naman, it has a prior state use. Kaya lang, the government is already abandoning its use of the property or its intended use. So, it is now converted into patrimonial property. So, again, the question, is there a need for a formal declaration? Okay, so that the property can be classified as patrimonial property? Okay. As I've said, it was answered in Republic versus Pasig Rizal case. Sabi ng Supreme Court, before kasi, in the Malabanan case, if you remember the Malabanan case, sinabi lang sa Malabanan case ng Supreme Court, if it is patrimonial property, there is a need. Okay? There is a need. Regardless kung anong klaseng patrimonial property yan. Basta, there is a need for a formal declaration. But, in the case of Republic versus Pasig Rizal, sabi ng Supreme Court, if there is prior state use, okay, we are referring to converted patrimonial property, the land must not only be classified as alienable and disposable, but there must also be a formal declaration or a positive act on the part of the government that the land is no longer needed for public use, public service, or for the development of the national wealth. Okay? For the property to be classified as patrimonial property. And this declaration shall be in the form of law duly enacted by Congress, or it can be through a presidential proclamation in cases where the president is duly authorized by law. Okay? So, without such declaration, the property, okay, even if it is classified as alienable and disposable, will remain property of public dominion. Thus, in that case, the period of acquisitive prescription will begin to run only after such formal declaration. Okay? Only after the formal declaration, not the classification as alienable and disposable. Okay? Now, if there is no prior state use, there is no need for a formal declaration for the property to be classified as patrimonial property. Okay? Because sabi ng Supreme Court, the mere classification of the property as alienable and disposable land of the public domain is enough for the property to be classified as patrimonial property. Okay? Ayun ang tatandaan nyo. It depends. Okay? Now, we go to the other amendment brought by RA 11573. Okay, specifically as to the proof required under RA 11573 to establish the status of land as alienable and disposable. Okay? Iba-iba kasi ang nag-iiba-iba ang requirement under the present law. There is you need only to present the approved survey plan bearing a certification issued by the DNR geodetic engineer, which states that the land subject of the application has been classified as alienable and disposable land of the public domain, bears reference to the applicable forestry administrative order, DENR administrative order, executive order, or proclamation classifying the land as such, and lastly, indicates the number of the land classification map covering the land. And sabi ng Supreme Court, under that law, this certification shall be sufficient proof of its classification as alienable and disposable land. Yun lang ang kailangan mong i-present. In the absence of a copy of the relevant issuance classifying the land as alienable and disposable, ang sabi sa batas, the certification must additionally state the release date of the land classification map and the project number. So, yun lang ang pwede mong ipalit. Okay? And Furthermore, the certification must confirm that the land classification map forms part of the records of NAMRIA. Okay, you know NAMRIA, the National Mapping and Resources Information Authority, and is precisely being used by the DNR as a land classification map. So yun ang additional requirement if you cannot provide the relevant issuance. Okay, classifying the land as alienable and disposable. And aside from presenting that certification, you must also present the DNR geodetic engineer as a witness. Okay? The purpose is to properly authenticate the certification that he issued. Okay, o kailangan i-present, sabi sa batas. Okay, so that's with respect to the proof required, okay, to establish the status of the land as alienable and disposable land of the public domain. There are other pronouncements of the Supreme Court in the Republic versus Pasig Rizal case. One, sabi ng Supreme Court, RA 11573 shall apply retroactively to all applications for registration. Okay? It will, kahit pending na yung case mo, halimbawa, hindi mo na-prove yung possession since June 12, 1945 kasi your possession started only in 1950, pero pending pa din yung case mo, since nag-take effect na yung RA 11573, you can still continue your application under RA 11573. 20 years na lang ang kailangan mong prove. Hindi na yung June 12, 1945. So yun ang retroactive application of RA 11573 on pending applications for registration. Even kung nasa appeal na. Okay? Hindi lang yung nasa trial pa. Including those applications pending before the Court of Appeals. And even sa Supreme Court, ganun din. In fact, one example is the case of Republic versus Pasig Rizal. It applied retroactively. That's why it remanded the case to the Court of Appeals for further presentation of evidence. Okay? Okay. So yun ang other pronouncement. Retroactive application. Okay? So just a few discussion dito sa case ng Republic versus Pasig Rizal Company. Yung background. Okay? So in 2010, Pasig Rizal Company Incorporated or PRCI filed an application for original registration of title over a parcel of land which the corporation and its predecessors in interest have been in open, continuous, exclusive, and notorious possession for more than 50 years or since 1956. So, hindi sila nakaabot ng June 12, 1945. So, PRCI invoked Section 14 of PD 1529 for its application. And ang sabi ng Supreme Court, since hindi man sila nakaabot ng June 12, 1945, ang ini-invoke nila is yung Section 14.2 or yung prescription. Okay. Now, yung nag-present ng dalawang certification yung PRCI, but these are not the certification mentioned in RA 11573. Okay. The application was granted but the Republic assailed the decision. And ang sabi ng Solgen, there must be an express declaration, okay, from the government that the property is no longer retained for public service or the development of national wealth before it can be classified as patrimonial property. Now, it happened that while the case was pending in the Supreme Court, RA 11573 took effect, okay, in 2021. So the issue in this case is whether PRCI is entitled to a registration over the subject property despite the absence of an express government declaration. And as discussed already a while ago, if there is no prior status, there is no need for a formal declaration for the property to be classified as national property. But the Supreme Court, again, it nonetheless remanded the case to the Court of Appeals to allow PRCI to present the required certification under the new law, yung RA 11573. Okay? So yun ang nangyari sa case na yan. Now, going or moving forward, let's see other amendment under RA 11573 insofar as free patent. Okay, yung agricultural free patent under the Public Land Act. Take note that the period of possession was also pegged at 20 years. Okay, so possession for at least 20 years prior to the filing of an application for agricultural free patent. Uh, 20 years na lang din. Okay? And take note also, insofar as free patent, yung 5-year restriction, remember the 5-year restriction against alienation, this was already removed under RA 11231 in 2019. Also, the right to repurchase was also removed under RA 11231. And corporations, associations, or partnership can already apply. This is also under RA 11231. Okay? Which took effect in 2019. Okay, we go to the next one, Decree of Registration 4.2. Now, the decree of the registration is issued by the administrator, di ba? And take note, there is no prescription for the issuance of the decree of registration and the certificate of title. Okay? Because it is the duty of the government and it's not the obligation of the applicant. Marami kasing nangyayari niyan, hindi nakaka-issue ng decree and certificate of title. Can it still be issued despite the lapse of time? Yes, because there is no prescription. Now, for decree of registration, I want you to focus on the indefeasibility or incontrovertibility of the decree, which happens after 1 year after the entry of the decree. Because this 1 year period is a prescriptive period. Now, we have the case of Sanson versus Tapus, GR number 245914, decided on June 16, 2021. This is also a recent case. Okay, just a few factual background. So in 2019, respondents sued petitioners for declaration of nullity of OCT number RO2222 and its derivative titles, claiming that their predecessor in interest had been in continuous, exclusive, adverse, and open occupation and possession of several parcels of land in the concept of owner for more than 50 years. Okay. They allege that OCT number RO2222, which was issued in 1932, and its derivative titles are void. Ina-assail nila ang isang OCT na na-issue pa in 1932. The case was only filed in 2009. Ang issue lang is the case barred already by prescription? And the Supreme Court said yes. Because OCT RO2222 was issued way back in 1932 while the case was filed in 2009. So under Section 38 of Act Number 496 or the Land Registration Act, the decree of registration shall not be opened, okay, by reason of the absence, infancy, or other disability of any person affected thereby, or by any proceeding in any court for reversing judgment or decrees. Subject, however, to the right of any person deprived of land or of any state or interested in by decree of registration obtained by fraud to file in the court of land registration a petition for review within 1 year after the entry of the decree. So you have only 1 year from the entry of the decree to file a petition for review of the decree. After the lapse of this period, prescription will already set in. Okay? And after that, the title will already, or the decree will already become incontrovertible and binding upon all persons and the whole world. Okay. So far as the incontrovertibility or in this indivisibility, just take note of the three exceptions to this one. First one is the land is already registered. Of course, the incontrovertibility or indivisibility of the decree will no longer apply. Or if the land is non-registrable, okay? Because if you even if you register a land that is non-registrable, it is still void. Okay? And lastly, if it involves an expanded area. Okay? Do you recall yung expanded area? It's a portion of the property na naisama doon sa title na hindi mo naman in-applyan. For example, nag-apply ka for 100 square meters, ang naibigay sa iyo ng court is 130 square meters. Yung 30 square meters is considered as an expanded area. So, hindi mag-a-apply yung indivisibility or incontrovertibility of the decree. Now next, 4.3, review of the decree of registration. Okay, just take note, it can be filed by any person, whether party or not. Okay, and it will be filed before the court which rendered the decision. And of course, the 1 year period, that's the prescriptive period for the filing. And just take note of the grounds for the petition. Okay. Now, number 6, certificate of title. I want you to, we will focus on the one of the doctrines affecting title. Okay, yung collateral attack, because dito ang mayroong bagong case. And this one is specifically penned by the chairman, Justice Hernando. Okay. Collateral attack, you all know that the validity of the title cannot be attacked collaterally, and it cannot be altered, modified, or cancelled except in a direct proceeding. So, a direct attack on a certificate of title may be done by filing either an original action or a counterclaim. So, sa dalawa lang na yan, mayroong direct attack. Okay. Now, let's see the case of Garcia versus Esclito. This is GR number 207210, decided in March 2022. Okay. Now, in 1979, Antonio Garcia purchased from Conchita a 29-hectare parcel of land located in Davao through a deed of sale. In 1998, he divided the land and donated portions of it to his children and grandchildren, the petitioners in this case, through deeds of transfer of rights. On November 17 to 25, 1998, petitioners were issued their respective patents and thereafter certificates of title. In 2003, respondents who are holders of certificates of land ownership award issued by DAR on December 1998 filed a petition for the annulment or declaration of nullity of the deed of sale and all the deeds, documents, and proceedings relying thereon before the office of the provincial adjudicator of Darab. The respondent alleged that the 1979 deed of sale was void for violating the Comprehensive Agrarian Reform Law. They likewise prayed to have the certificates of title of petitioners cancelled or annulled. The issue here is whether the petition before the provincial adjudication constitutes as impermissible collateral attack on petitioner's torrent certificate of title. Okay? Sabi ng Supreme Court, yes. Because Section 43 of PD 1529 states that the certificate of title shall not be subject to a collateral attack and cannot be altered, modified, or cancelled except in a direct proceeding in accordance with law. Here, although respondents mainly sought the nullification of the deed of sale, they also alleged that such instrument ultimately gave rise to the issuance of certificates of title in favor of petitioners. Hence, their express prayer to have the certificates be cancelled or nullified as a consequence. So, indeed, to attack the deed of sale would be to effectively attack the certificates of title. Once the deed of sale is nullified by the DARAB, the cancellation of the certificates will logically follow, reducing the succeeding cancellation proceedings to be a mere formality. Okay? So again, hindi ka pwede sa DARAB magpa-cancel ng certificate of title or ng dito, deed of sale. But sabi ng Supreme Court, if you cancel the deed of sale, it will be a collateral attack on the certificate of title issued uh, as a result of the deed of sale. Okay? So that's the Garcia versus Scleto case. Okay? Now, it's 2:15. Okay, tapusin na natin. So we move on sa 4.3.1, yung innocent purchaser for value. Okay? Just take note, okay, of the three conditions that must occur for a buyer to be considered as a buyer in good faith. Okay? These conditions were stated in the case of Sulit versus Spouses Alfonso, GR number 230599, dated January 20, 2021. Okay, the first condition is that the seller is the registered owner of the land. Because if you are going to buy a property, of course you must transact with the registered owner. Okay. Second, the seller is in possession thereof. Because if it is in the possession of another person, of course you have to doubt, okay, if the seller is really the owner of the property because someone else is in possession. And lastly, at the time of the sale, the buyer was not aware of any claim or interest of some other person in the property or of any defect or restriction in the title of the seller. Okay? Now, if any of the condition is absent, okay, you have to exercise a higher degree of diligence. Okay? So you have to scrutinize the certificate of title and examine all factual circumstances in order to determine the seller's title and his capacity to transfer any interest in the property. Okay? So, for buyer in good faith, I want to discuss the this is a very important one, okay, because this is a new rule in the determination of the status of a buyer as a buyer in good faith or not. Okay. Now, before, okay, before, in cases other than double sale, the rule is that the buyer the buyer needs only to be in good faith at the time of the execution of the deed of sale. So after the execution, kahit pa may uh, ma-register na, for example, an adverse claim in the certificate of title in the ROD, it will no longer affect the status of the buyer as a buyer in good faith. Now, this is a new rule, and you have to take note of this. And uh, this can be a good source of question in the bar exam. Now, the new rule, again, I will now state the new rule. So, the determination or the reference point in determining the status of a buyer as one in good faith or not is at the time of the registration of the deed of sale. Okay? At the time of the registration of the deed of sale in the ROD. That rule is now the same as the rule on double sale. Okay? So the requirement now is the registration must also be in good faith. Okay? Saan yung pronouncement na yan? It was in the case of Duenas versus Metropolitan Bank and Trust Company, penned by Justice Hernando. Okay? It's GR number 209463, dated November 29, 2022. Okay? Um, just to simplify, uh, yung Metro Bank, okay, it acquired, it bought a property from AFRDI, okay, from a company. Binili ng Metro Bank. Now, yung Metro Bank did not register immediately the deed of sale. Okay? Now, before it was able to eventually register, the Philippine Association of Law Schools
Hello, everyone. Due to some heavy rainfalls that we currently have, we just had some technical problem, but rest assured that we will continue with the rest of the lecture. Again, we would like to thank our sponsors and collaborators. And if you have questions, as early as now, you may comment it down to be previewed later after the lecture for the Q&A portion. And but if you don't have, I'll be giving in the floor to our lecturer. Welcome, Dean. If you are, thank you. So while we're waiting for our lecture, you may. Oh,
Good afternoon again.
good afternoon, Dean. Welcome back again, Dean.
Ah, na, Napansin ko naputol. Okay. Shall we continue? Okay. So, uh, dito na tayo sa number 7. Subsequent registration. Okay. We focus on adverse claim only and notice of lispendence. They are the ones mentioned in the syllabus. Now, take note that the adverse claim is effective for 30 days, but it will remain to be effective thereafter unless it is cancelled by court. Okay? So, kahit 3 years na yan dyan, if it has not been cancelled, it is still effective. Although sabi ng law, 30 days lang ang effectivity. Okay? So baka may bar question na ganun ang situation. So you can answer that way. And yung notice of lease pendants naman, usually ang tinatanong sa bar is uh, they are required to distinguish adverse claim and notice of lease pendants. Now, there are two differences between the two. Number one, an adverse claim protects the right of a claimant during the pendency of a controversy. Okay, the word is controversy, while a notice of lease pendants protects the right of the claimant during the pendency of an action or litigation. Okay, so yung notice of lease pendants, there is a actual case filed in court. Pag adverse claim, kahit wala pa, as long as there is a controversy. And an adverse claim can only be cancelled upon filing of a petition before the court, which shall conduct a hearing on its validity, while a notice of lispendence may be cancelled without a court hearing. Okay? And then, number 8, go to number 8, non-registrable properties. You just memorize what are the non-registrable properties. Number 9, dealings with unregistered land. Pag unregistered land, we always apply the rule that whatever the right of the seller are the only ones that are transmitted to the buyer. If the seller has no right, the buyer will have no right. Okay? So, sabi nga, let the buyer beware. Okay. Now, for assurance fund, okay, ito na yata ang ating last discussion. For assurance fund, take note of the conditions for compensation from assurance fund. I think you need to memorize those. But ang pinaka-importante is the prescriptive period of 6 years. Okay? Now, the question is, when will the 6-year prescriptive period be reckoned with? Okay. Ang sagot, of course, for purposes of determining the right to bring an action against the assurance fund, the prescriptions should be reckoned from the moment the innocent for value register his title. Okay? So once na ni-register na ng innocent purchaser for value yung title, and upon actual knowledge thereof of the original title holder or claimant. Okay? So dalawa ang requirement, hindi lang from the time na na-register ng innocent purchaser for value ang kanyang title, but upon actual knowledge of that by the original title holder. Yun ang sinasabi ng Supreme Court. Dapat may actual knowledge nung registration yung title holder before prescription will commence to run. Okay. And take note that there is no need for a prior declaration of insolvency before a claim against the assurance fund can be made. Okay. There is no need for a prior declaration of insolvency. Okay. And number 11, uh, let's discuss this one because um, although I think this might not be asked in a bar, but there is one case kasi decided by the bar chair in February 2022, the case of Republic versus heirs of Eduardo Buok. Anyway, this concerns merely a defect in the uh, notice of hearing in a case for issue. Uh, this is about reconstitution of certificate of title. Okay? Sa reconstitution of, take note lang, pag reconstitution, if it is administrative reconstitution, there must be substantial loss. And pag sinabi natin na substantial loss, it must be at least 10% of the title in the ROD and not less than 500 certificates of title. Yun ang substantial loss. And the cost must be due to fire, flood, or other force majeure. That is for administrative reconstitution. Otherwise, you need to avail of the judicial reconstitution. Now, for reconstitution, in this case of Republic versus heirs of Eduardo Buok, okay, um, the notice of hearing, di ba, there will be a notice of hearing. Ang problem is that the notice of hearing did not state the specific certificate of or certificates of title involved in the case. Okay? The lot was mentioned, but the certificate of title, the number of the certificates of title were not mentioned. Okay? Ang sabi ng Supreme Court, this is a violation. And because of this, the court will not acquire jurisdiction over the petition for reconstitution. Pero aside from that kasi, aside from the failure to state the number of certificates, may additional circumstance pa, okay, which was used also by the Supreme Court in declaring that the RTC did not acquire jurisdiction. Specifically, the names of the occupants and possessors of the lot were not mentioned in the notice of, or they were not indicated in the notice of hearing. And then the area and the boundaries of the lot were not also indicated in the notice of hearing. And lastly, the date on which the all persons having interest therein must appear and file their claim or objection to the petition was not also mentioned in the notice of hearing. So all in all, because of this failure of the failure in the proceedings, the Supreme Court concluded that the RTC did not acquire jurisdiction on the petition because of these fatal defects. Okay, so that's it. Those are the new cases in land titles and deeds that are connected to the syllabus for the 2023 bar in land titles and deeds. So I wish you all the luck, everyone, and I hope that you will all be good lawyers someday. Okay, so maybe we will see each other in court in the future. So thank you very much. Thank you also for to pals.
We would like to extend our heartfelt appreciation for our lecture for today, and for sure, a lot of our baristas have been refreshed by your guidance, Dean Milano, for the upcoming bar examination. And at this moment, we'd like to open the floor to the audience in our Facebook Live. If you have any questions for Dean Milano, please comment it down. Thank you. We'll allot 5 minutes for that, guys. So you may take the time to comment down your questions so that we can answer. Okay, there are a lot of comments on our Facebook page thanking our dean. Thank you very much, Dean. We have a lot of fun, Dean, in our Facebook page. Okay, no questions. Just thanking our lecturer for today. Okay, I think we don't have any more questions, Dean. I'll be giving the floor back to you, Dean, if you have any good luck message to our baristas.
All right, sige.
Oh, I think there's a question being served for that. So, in the case of a Filipino who reacquired the citizenship, how much area of land is the person allowed to buy as a property?
Well, if you reacquired your Filipino citizen, you are considered as a Filipino. So there is the limitation is only 12 hectares. But don't be confused, okay? Because insofar as private properties, of course, you can acquire as many as you want. But for uh, uh, property of public dominion, you are only acquired to acquire up to 12 hectares. That's the limitations set forth in the Constitution.
I think that answers the question of Miss Auntie. So, if you guys don't have any questions anymore, do you have any message about our baristas team?
Okay, again, I wish them all luck. Just pray because God will uh, lead you, will guide you through the Holy Spirit. Okay, it's good
Mhm.
that you pray every day. When I was taking the bar exam, I really pray very hard.
Mhm. Thank you again, Dean. That message was really helped them and will give them strength to pass the bar examination. So may I remind everyone that for our next discourse, it will be August 4 for commercial law, taxation on August 7, political law on August 9, labor law on August 11, and legal ethics on August 14. So again, of course, this event will not be possible without our collaborators, ALSP National, PUP College of Law, and sponsors Rex Education and Central Books. And for our lecturer for today, Dean Milano. Once again, thank you again, everyone, for attending today's lecture. Hoping to see you again on our next discurso. Bye.